Good evening. To tonight's presentation. I'm sorry about my voice. We're here for the 6 at 6 lecture series. It's our 15th season. I'd like to take a moment to recognize Mark Nykirk in the audience. He started this 6 at 6 series, so thank you, Mark, for your shoulders that we stand on tonight. So the 6 at 6 lecture series is a series of 6 lectures at 6 p.m. Where we bring NKU faculty into the community to do lectures of public note. Shall we try again? We are joined by folks online, which is why we are using the microphone, not because you all can't hear us. So when we get to the question session, if you would mind using the microphones to help us and our folks online. For those of you who are joining us online, there is a chat box that you can put questions, and we will funnel those through our speaker. So with that, our speaker tonight is Professor Michael Mannheimer, who has a national reputation for being a legal scholar about the interpretation of the Constitution, particularly the Fourth Amendment, which is why we're all here tonight. He's been recognized for this work by the American Law Institute, which is the leading organization in the United States for lawyers, judges, and scholars to clarify, modernize, and improve the law. Professor Mannheimer is also inspired by bringing rooting out systematic racism and implicit biases that continue to plague our legal system. And he'll be talking a little bit about that tonight through his presentation. So with that, I invite Michael up to talk about the Fourth Amendment. Thank you.
All right, thank you so much, Shauna. Let me just start my timer so that I don't go over. Thanks, Shauna, and thank you to Devin and to Mark and the Scripps Center and the Barringer Crawford Museum for having me here for this 6 at 6 lecture. I'm very honored to be part of the 6 at 6 tradition tonight. So I'm here to talk about my book, The Fourth Amendment, Original Understandings and Modern Policing, right here, just to show you it's an actual book. I am going to assume that most of you are non-lawyers, so I have different versions of this talk. This is going to be the one that's geared towards non-lawyers. But if I lapse into lawyer mode, if I start talking about things that you don't understand, please feel free to stop me and say, what does that word mean? I'm going to talk for about 40 minutes or so. I'll try to, and then we'll have time for discussion and Q&A. So let me just start by talking about originalism and, what is originalism and why do we care? So two characteristics of originalism. I'm not going to talk too much about this. It's just sort of an introduction into my work. The constraint principle, that judges are constrained by original meaning. I'm not going to defend that. I'm just going to assume it so we can get to the Fourth Amendment more quickly. The fixation thesis, I will talk a little bit about. That's the idea that the meaning of a constitutional provision was fixed when it was written and when it was adopted. There are different ways of thinking about that. One school of thought is that the words of the Constitution meant precisely what they said when they were adopted. That's a really difficult position to take, I think, for anyone, because if you think about the Second Amendment, the word arms. I mean, if the word arms meant only what it meant in 1791, we'd have a right to have muskets and cannons and nothing else. Well, it certainly has to extend beyond muskets and probably doesn't extend to cannons. So we have to use some other way of thinking about it. The other way of thinking about it is that when the reference of the words of the Constitution change, that can also change the application of the constitutional provision. So for example, just to put it sort of layman's terms, if I'm sitting at a dinner party and my wife is sitting to my left and I say to someone, whenever I'm at a dinner party, I usually end up spending most of my time talking to the person to my left. That could mean two things, right? That could mean I spend most of my time talking to the person who's currently to my left, my wife, or it could mean I spend most of my time talking to whomever is at my left at the dinner party. From the context, we know it's probably the latter, because if I meant my wife, I probably would have just said my wife. So the more general the wording, the more justified I think we are in looking to what the framers and ratifiers of the Constitution might have meant beyond the immediate reference of the terms at the time they were written. And of course, that has relevance to the term unreasonable searches and seizures. One final misconception I wanted to kind of clear up before we start talking about the Fourth Amendment. Hey, isn't originalism just for conservatives? No. There are plenty of progressive originalists, including myself, and I'll give you an example of an originalist argument that can be put in service of a more progressive goal. Some years ago, I researched the cruel and unusual punishments clause of the Eighth Amendment. And based on my research, I concluded what they meant by cruel and unusual punishments is that the federal government cannot impose a punishment that is unauthorized by the law of the state where the crime occurred. Meaning, for today, the federal government cannot execute someone for a crime in a state that has no death penalty, even if it's a federal crime. So that could be used in service of a more progressive argument. That's not why I came to that conclusion. I came to that conclusion because I thought that was the best way of reading the materials. So let me start talking about the book. So there's 3 parts to the book and 3 parts to my talk. I'll talk about the Fourth Amendment, and then I'll talk about the 14th Amendment, which applies the Fourth Amendment to the states. And then I'll talk about how, what relevance this all has to modern policing. So the Fourth Amendment says that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. That's a real word salad. But what we really want to focus on is this, the term unreasonable searches and seizures. That's the big question. What makes a search or seizure reasonable or unreasonable? Some people say, well, if it's it has to be conducted pursuant to a warrant. And that's kind of the position the Supreme Court has taken over the years. A search is unreasonable if the police don't have a warrant. Or we could, the problem with that, one problem with that is that the court has made exceptions to that. So again, we have to kind of fall back on, well, what are the exceptions? What makes a search unreasonable if it's a search that we don't think needs to be conducted pursuant to warrant? So what the court has done is to look at the common law of 1791. When I say the common law, I mean the law as formed by judges hearing cases over years and decades and centuries. So for example, the court has said that even a warrantless arrest, an arrest that's not conducted pursuant to a warrant, has to be supported by probable cause. That's not anywhere in here. It talks about probable cause having to be as the measure of what makes a warrant acceptable. But it doesn't anywhere say that an arrest without a warrant has to be supported by probable cause. So the court has looked to the common law of 1791 to answer that question. 2 problems with looking at the common law of 1791 to determine what makes a search or seizure reasonable or unreasonable. First is that the court is looking at things, or tends to look at things at the wrong level of generality. The Fourth Amendment doesn't talk about searches and seizures conducted contrary to the rules of the common law as it exists today, that is in 1791. It just says unreasonable. They were referring to the common law, but not the common law of 1791 frozen in time. It's like the example I gave a few minutes ago of when I said the person sitting to my left, I didn't mean just my wife, I meant whoever happens to be sitting to my left at the time. They were referring to the common law as it was expected to develop over time and as supplemented and reinforced by legislation. And when they meant the common law as it develops over time, they also meant state law. because the common law differs by state, and it differed by state back then, and they knew that it differed by state. There's lots of statements around that time period where they talked about the common law being different in different states. The Fourth Amendment at the outset applied only to the federal government, so the idea was that search and seizure rules would apply to federal officers and agents, and those search and seizure rules would be the search and seizure rules of the particular state where they were acting. If it's a customs official in New York, then New York law applies, and so forth, because search and seizure rules were enforced primarily through state court civil suits. So I've come up with what I call the local control model of the Fourth Amendment, which is that unreasonable searches and seizures are those that are in violation of state law. So it's impossible, or at least it was at the beginning, for federal agents to violate the Fourth Amendment the way we talk about officers violating the Fourth Amendment today. That would have been sort of incoherent to the framers and ratifiers. What a federal official would violate is state law, right? And only Congress can violate the Fourth Amendment by giving federal agents immunity from suit or by allowing warrants to issue too readily. The second problem, I mentioned there were two problems with looking at the common law of 1791. The second problem is that the Fourth Amendment now is understood to constrain the states, not just the federal government. And the reason that it constrains the states is that it's thought the 14th Amendment, adopted in 1868, incorporates the Fourth by reference and applies it against the states. But if most of what we're looking at now is the Fourth Amendment as it applies to the states, why are we looking to 1791? We should be looking to 1868 when we decided, hey, these restrictions will apply to the states from now on. So we have to look at the 14th Amendment, and that's the second part of my talk. Here's the text of the 14th Amendment. I'm not going to read it out to you, but it's basically got four pertinent clauses in Section 1. There are other sections of the 14th Amendment. Section 1 has four pertinent clauses. The Citizenship Clause, which has been in the news lately. The other three clauses are the ones that we talk most about in the law: the Privileges or Immunities Clause, the Due Process of Law Clause, and the Equal Protection of the Laws Clause. So that's just the text. How do we figure out what these mean and to what extent these impose or should be thought to impose search and seizure constraints on state officials? Well, we have to look to the history, not just to the text. We have to look to the historical backdrop of the 14th Amendment. What motivated Section 1? And there were two things, basically, that motivated Section 1 of the 14th Amendment. First, Southern violence against black people, and to a lesser extent, loyal white people and Northerners. Just horrific violence in the aftermath of the Civil War against black people. Second, the Southern Black Codes that were passed in the wake of the Civil War. These consisted mostly of race-conscious laws that differentiated expressly by race, but there were also race-neutral laws that were being applied in a discriminatory manner. Mostly I'm talking about the vagrancy laws. And I'll show you Kentucky's vagrancy law. Almost all of the formerly Confederate states passed new vagrancy provisions. Kentucky, which had not been a Confederate state, they stayed loyal to the Union, but had been a slave state, passed a vagrancy law also. First, notice the date. This is February 1866. The 13th Amendment abolishing slavery had been passed in December of 1865. So it took the Kentucky legislature all of 2 months to come up with a way to basically reinstitute slavery. And the way they did that was to say that if any able-bodied person be found loitering, rambling about, not having means to maintain himself, without suitable means of subsistence, or who is idle or dissolute in habits without visible means of support, shall be taken and convicted as a vagrant. And the punishment for vagrancy was to have your services hired out to someone for a period of a year. Now, notice the breadth and the vagueness of these provisions. Someone just standing around on a street corner or standing around in a field doing nothing, well, they could be considered a vagrant. Even if they've been working, hard at work 5 minutes earlier, if they're just standing around, they could be considered a vagrant pursuant to these provisions. And guess who it was enforced against? And again, the punishment would be to hire them out to someone, a white person. And here's the dead giveaway in the Kentucky statute, that this was designed to basically reinstitute slavery. When hiring out the services of that person, preference would be given to those having heretofore owned the service of such convicted person. That is to say, the former slave master of the formerly enslaved person. So, to address these problems, violence against black people and things like the vagrancy provisions and the black codes in general, the Reconstruction era Republicans framed and ratified Section 1 of the 14th Amendment. Remember, during this time period, it was the Republicans who were the more progressive party, the Democrats were the more conservative party, and this was one of the very, very few times in history when progressives ruled the roost. Because the Democratic stronghold was in the South, but the South was not represented in Congress during this period in the immediate aftermath of the Civil War. So it was overwhelmingly Republican in Congress. There was a Democrat in the White House, Andrew Johnson, but the Republicans had a supermajority in Congress. So they could basically do whatever they want, including overcoming President Johnson's veto of things like the Civil Rights Act of 1866. So what Section 1 was meant to do was to give freed black people in the South and other, undesirables, loyal white people and Northerners who had relocated to the South, to give them freedom from arbitrary or unlawful intrusions on their lives, liberty, and property. But at the same time, preserving our basic federal structure. There were some radical Republicans in Congress who would rather not do that, but they had to compromise with the more conservative and more moderate elements of the Republican Party. So they left most of the decisions about civil rights up to the states, not the feds. And another goal of the Reconstruction era Republicans was to preserve democracy. They were very optimistic about democracy. Too optimistic, it turns out. But they thought, if we give black men the right to vote, they can basically take care of themselves. Again, they did not put the right to vote in the 14th Amendment. That was a little bit too radical for them at the time. They did so sort of by indirection in Section 2 of the 14th Amendment. They thought that would give black people the vote. I won't get into the weeds too much on that. But 2 years later, they explicitly gave black people the vote, or black men the vote, I should say, and they thought that that would basically do the trick. If black men could vote, they could take care of themselves. So the idea was to ensure rights while also preserving federalism and majority rule. So the 4th and the 14th Amendment together, I suggest, require states to protect through legal mechanisms as determined by democratic lawmaking, be it common law, statutory law by the legislature, or what we would call administrative law, to protect the right to be free from arbitrary searches and seizures. And they endorsed what we would call a representation reinforcing view of the Fourth Amendment. They wanted to leave states largely free to implement their own policies through democratic channels, including search and seizure policies, but with the courts kind of policing those political channels for signs of process failure. If you haven't read Democracy and Distrust by John Hart Ely, and I'm assuming a lot of people haven't, if you're interested in constitutional interpretation, it is, in my view, the best book ever written on constitutional interpretation. It's 45 years old already, but it's still at the best. John Hart Ely, Democracy and Distrust, and a lot of what I'm talking about comes from him, this kind representation reinforcing view of the Constitution that the default is democracy and courts have to step in only when there's the specter of process failure in the democratic process. Well, what do I mean by process failure? Well, that can occur in a number of different ways. The laws can be discriminatory, right? That's sort of obvious, right? The majority is unwilling to impose on itself the same burdens it imposes on the minority. The majority is internalizing the benefits and externalizing the costs of security and order. Process failure can occur, maybe even more obviously, when state agents just don't follow the law. They disobey the law. Process failure can occur when state agents are vested with excessive discretion, right? Because we know what's going to happen. We saw it with the vagrancy provisions. They're going to place the burdens on the minority, even if it's a race-neutral law. At some point, excessive discretion is like having no constraints at all, right? If the legislature passed a law that said, police, you can arrest anyone you think has committed a crime, right? Well, there's a law, right? The state agents are at least obeying the law, but it gives them so much discretion. We may as well not even have that law. All right. So how does that cash out? Those are sort of the three guiding principles of the 14th Amendment. Non-discrimination, again, sort of self-explanatory. Legality, right? State agents can act only as authorized by and consistent with state law, either through laws of general application or special authorization by the legislature. What do I mean by that? Laws of general application. The law against trespass, right? We're all bound by the law against trespass. We can't trespass in someone's house, so neither can the police, right? They have to follow the same law that we follow unless they're given special authorization by the legislature to do things that we can't. And of course, the legislature does that. It gives the police certain powers to do things that we can't do, right? That will pass the test of legality, but then it might come up against the constraint of non-delegation, right? And there's two concerns here. There might be an excessive delegation of power from the legislature to the executive. Like I said a moment ago, if the legislature passes a law that says, police, go enforce the laws, right? That's just excessive discretion on the part of for the police. And then there could be excessive discretion given to individual officers in the field. And we have to worry about both of these types of delegation of power. All right. So, how does this view of the Fourth Amendment and the 14th Amendment cash out, as we academics like to say, in terms of modern policing? Well, let's look at one place where the court has gotten it sort of right, not completely right. How many people have ever gone through a sobriety checkpoint? I know I have. Once I was up in Toledo. They didn't stop me, but I had to go through it. Sobriety checkpoints were blessed by the Supreme Court in a case called Michigan Department of State Police versus SITS 35 years ago. And let's test sobriety checkpoints against our three principles. Non-discrimination, yes, it passes the test because the police don't pick and choose who they're stopping. They have to stop every person or every fifth person or every 10th person or whatever it is. Of course, there could be discrimination in where they decide to put the checkpoint or the roadblock. We have to worry about that, okay? Let's put that to one side for now. Legality. Are these authorized by law? That's where this SITS court, I think, makes a mistake. I mean, it wasn't raised by the parties, so it's not their fault. And the Supreme Court has said, really, state law doesn't have much to do with the Fourth Amendment. I think they're exactly wrong about that. I think state law has everything to do with the Fourth Amendment and the 14th Amendment, that police activity has to be at least authorized by law. That's the very least. That's the floor. And sobriety checkpoints were not authorized under Michigan law. I won't read the statute, but it basically says, police go enforce the law on the highway. It doesn't say anything about sobriety checkpoints. As opposed to a state like New Hampshire, which does specifically authorize sobriety checkpoints. All right, what about non-delegation then, right? New Hampshire permits sobriety checkpoints. No discretion is given to individual officers, right? Because they have to stop every third car, every fifth car, whatever it is. But notice in New Hampshire, and again, I won't read the whole statute, but New Hampshire says you can have a sobriety checkpoint if the law enforcement officer goes to the judge, and that's a good thing, bringing in another branch of government. That is a check upon tyranny, right? But notice what the standard is. The court has to issue an order authorizing the checkpoint after determining that the sobriety checkpoint is warranted. That doesn't give courts any guidance as to when a checkpoint might be warranted. So my view is that fails the test of non-delegation. It gives too much discretion to police and to the courts acting together. As opposed to a state like Iowa, Utah has a similar statute. There are other statutes. Again, don't read the whole thing. But the point is, they specifically tell us what we should look to in determining when police can set up a checkpoint, right? Authorizing the police to set up a checkpoint. At the very least, it has to be authorized by law. I can't go out onto the road and start stopping cars, right? That means the chief of police can't do it either unless there's a statute saying that they can do that. All right, let me show you one place where I think the court has gotten it wrong. And there's a lot of places where the court gets it wrong. And I'll talk about more of these. But collection of blood samples from suspected drunk drivers. I'm not going to ask who's undergone that process because it's a little embarrassing. So, you know, if you're arrested for drunk driving, in every state, police can forcibly take a blood sample from you, which is a search and seizure. So what are the justifications for doing that without a warrant, right? The court has said, well, there's an exigency there because the evidence of blood alcohol content disappears over time. As the seconds tick away, it's disappearing. So police have to act quickly, get the blood sample, right? They've also said, well, maybe it's a search incident to arrest. When the police arrest someone, they can search their person, they can search the pockets, they can search anything on the person. So maybe they can also go into the person and take their blood. Maybe that's a good justification for it. Or maybe it's about consent. When I get my driver's license, I impliedly consent that in exchange for being able to use the roads, the police can, if they have probable cause to think I'm driving drunk, they can take my blood. So there's consent. So the way I summarize the law, a little bit sarcastically in the book, is that warrantless breath tests are justified as searches incident to arrest, but not warrantless blood draws. However, warrantless blood draws are almost always justified by exigent circumstances when the driver's unconscious, but only sometimes when she's not, and may or may not be justified on an implied consent theory when refusal triggers civil consequences, but not when refusal is a criminal offense, except maybe when the driver's unconscious. I don't even try teaching that to my students. Why not just say this, all right? The democratically elected and politically accountable state legislature has required blood draws for anyone arrested for DUI. The overwhelming majority of voters drive. It's not as if drivers are some powerless, unprotected group whose interests are not taken into account in the political process. The existence of probable cause to arrest singles out this particular driver as the proper target for a search, and the blood draw is mandatory. The police have no discretion. They have to do the blood draw. Okay. So, the last part of my talk, I'm going to talk about what I call 4 problems of modern policing. The panopticon, what I call the panopticon problem, the problem of traffic stops and arrests for minor offenses. I'll just talk about traffic stops to keep it simple. The stop and frisk problem, and the problem of unjustified police violence. Okay, so what's the panopticon problem? The problem is technology is advancing at such a rapid pace that the government is soon going to be able to, if they're not already, able to surveil us without conducting a Fourth Amendment search, right? The court has said it's a search only if it violates your reasonable expectation of privacy, or if it's a trespass to your land or to your person or to a property, right? But with modern technology, police can surveil us without doing either of those things. I'll give you an example, which may be the hardest example. Poll cameras. Sometimes police, if they suspect someone of committing crimes, they'll put up a camera on a utility pole, pointed at, surreptitiously of course, pointed at the person's door, and be able to monitor their comings and goings and the comings and goings of any guests that they might have for weeks, months, years even, just constant surveillance of the door. Most courts have upheld this as not being a search at all because it breaches no reasonable expectation of privacy, right? Anyone watching your door could see you're leaving and you're coming back at a certain time every day. If someone were posted there continuously, constantly, they would be able to see all that. It doesn't trespass upon your land or upon anything else, right? So most courts that have addressed this issue, and the Supreme Court hasn't gotten there yet, but most courts have said that's not a search. The solution, or at least a partial solution, is the legality principle that require legal authorization for police to use surveillance technology that's unavailable to the rest of us. When surveillance technology is available for use by private citizens and by government alike, we can assume that the democratic process is working because we're all subject to being surveilled by our fellow citizens. And if that use of technology is not forbidden to private citizens, we don't really have a liberty interest there. So think about binoculars, right? I take the risk that someone walking down the street or in their home, when I'm walking down the street, is viewing me with binoculars. So they can see me very clearly, they can see me close up. They can do that legally, so the police can do that too, right? If we decide to regulate the use of a particular technology vis-a-vis other private citizens, that creates a liberty interest, right? So if someone uses binoculars to peer into my bedroom in a state of undress, that's a tort. I could sue them. It's in some places it might even be a crime for them to do that. So the police shouldn't be able to do that either, right? They shouldn't be able to do that, at least not with impunity, right? That would be a deprivation of liberty without due process because I now have a liberty interest in not being spied upon with binoculars in my bedroom. The legislature could give special dispensation to the police to use a technology in that sort of way, subject to sufficient limits on discretion to satisfy the non-delegation constraint. But notice, that has to go through the democratic process. Legislators have to come home and tell their constituents, yes, I voted to allow the police to use this sort of technology on you. When surveillance is available only to, or when a particular technology is available only to the police, again, we can't assume the democratic process is working because we're not all equally subject to being surveilled in the way we are if the technology is available to other citizens, right? For obvious reasons, the police are going to target certain people. I'm not going to be targeted. So in that case, when the surveillance technology is available only to the police, it has to be specifically authorized by the legislature. Again, subject to sufficient limits on discretion to satisfy the non-delegation constraint. So let's talk about traffic stops. The problem, virtually everybody commits traffic offenses. Virtually everybody speeds. Maybe not in Cincinnati, but in most places, people speed. People will go a mile an hour over the speed limit. And since virtually everyone commits these offenses, the police have virtually unlimited discretion to stop whoever they want. There was a study on the New Jersey Turnpike at one point that found that I think it was 98.1% of the drivers on the New Jersey Turnpike were speeding. Not too surprising if you've ever driven on the New Jersey Turnpike. But that's the universe of people the police can stop. Almost everybody. And there's overwhelming evidence of a racial dimension to this. Traffic laws are, it's been said, I'm not the one who made this up, but I think it's true. Traffic laws are the vagrancy statutes of the 20th and 21st century, right? Police can just do whatever they want because everybody speeds. What are some solutions to this? Well, we can eliminate discretion. When we can do that in at least two different ways, neither of which is going to be very popular politically. One is eliminate traffic stops entirely. I'm not sure why we have traffic stops anymore. We can use speed cameras. We can use red light cameras. We can use manufacturer-installed monitoring of automobiles. Of course, we all know there's pushback to these things, right? People don't like red light cameras. They don't like speed cameras. A good deal of that pushback, though, is coming from people who look like this, right? People who don't get stopped very often. People who are the beneficiaries of police discretion. I've been driving, almost 40 years, 39 years, and I've been stopped twice for speeding. Twice. And I speed all the time. And in part, I think it's a reasonable assumption to make, it's because I look like this. So the beneficiaries of police discretion are going to be against that sort of thing. Second possibility, which is also going to be unpopular, zero tolerance. Require traffic stops for anyone breaking any traffic law. Or, to be a little bit less draconian, require traffic stops of someone going, a certain number of miles per hour over the speed limit, 5, 10, whatever it is, right? But require it. Don't give police discretion. Again, a lot of people are not going to like that because they are the beneficiaries of police discretion. But those are two ways of limiting police discretion. And the fact that they're not politically popular is exactly the point, right? We live in a democracy. These things should be achievable through democratic means. If the pain is spread equally, then we get rid of that process failure. Everybody's going to feel the pain from being stopped all the time or from having red light cameras recording them. And so we can sort of trust at least a little bit more the product of the legislative process, right? Because angry old white men like me are going to call their legislators and say, hey, what's going on here? We've got to do something about this. The stop and frisk problem. So the court, in a case called Terry versus Ohio, said that police can stop and frisk someone if they have reasonable suspicion that the person has committed, is committing, or is about to commit a crime. The problem is, reasonable suspicion is a really low standard. It's lower than probable cause. You can point to a number of objective factors which in isolation don't really tell us much, but if you add enough of them together, that constitutes reasonable suspicion. The person is sweating, the person is nervous, the person is furtively looking around, there's a heavy object apparently in the person's pocket, right? Add these things up, that amounts to reasonable suspicion. Police can get to reasonable suspicion quite easily. They don't even have to identify what crime they think the person is committing, as long as there are enough of these objective factors that make the behavior suspicious. Again, overwhelming evidence of a racial dimension. You've read about this. You know about this from the news. What's the solution to this? Well, I don't say get rid of the reasonable suspicion standard. The reasonable suspicion standard has a place where there's some kind of emergency. That's what Terry versus Ohio was all about. It was about an emergent situation. One police officer, 3 men. He had reasonable suspicion that they were about to commit an armed robbery, and he had to do something about it. An armed robbery is very dangerous, right? He had to head off this dangerous situation. That's morphed into this incredibly broad power of the police to stop people. I say go back to Terry and limit stop and frisk to true emergencies. All right. Finally, the problem of unjustified police violence. Notice I say unjustified police violence because much police violence is justified. Police have to use force, whether ordinary force or deadly force sometimes, to make arrests, to keep order, and so forth, right? But there are cases of unjustified police violence, and police often commit crimes with impunity. And again, very strong evidence of a racial dimension. Before I said overwhelming evidence, it's less strong here, but it's still very strong evidence of a racial dimension. What's the solution to this? And this is going to sound sort of obvious, but prosecute the police when they commit crimes, right? Police are entitled to the same defenses that any ordinary person has when they're charged with using excessive force. Self-defense, right? We all have the right to self-defense. Defense of others. We all have the right to protect other people. Police are also entitled to certain law enforcement defenses. Use of force in making an arrest, for example, that the rest of us don't have. Again, they are given specific authorization by the legislature, or in some cases by the courts, to use force in those situations. Right? But prosecutors shouldn't add to those by simply deciding not to prosecute police when it's fairly clear they may have committed a crime. Right. So that's what search and seizure, what constitutional search and seizure law could look like if we paid less attention to the Fourth Amendment and more to the 14th Amendment. I'll go back to what I said at the outset. Originalism is not itself conservative. It's conservative when we're looking at a provision that was adopted during a conservative time period, right? If the people adopting it had a conservative viewpoint, and the Bill of Rights is actually fairly conservative in that way, to the extent that it is a pro-federalism, pro-states' rights document. But if we're using original understanding to look at a fairly progressive provision, a provision that was adopted during a fairly progressive time period, like the 14th Amendment, when progressives held sway, then originalism opens up new vistas that I think a lot of originalists don't realize. So instead of writs of assistance and general warrants, when we're talking about the Fourth Amendment, those were the bugaboos in 1791. The court should be talking about the black codes. The court should be talking about the massacres of black people in the immediate postbellum South. And the court should rely on local democratic controls on the state's search and seizure powers, hedged by judicial superintendents based on the principles, as I've said, of non-discrimination, legality, and non-delegation. That is just over 40 minutes. So I'll stop there and open up the floor for discussion, Q&A. Thank you, Ken. Yeah.
Did you say,
Oh, wait for the mic.
you seem to say offhandedly that citizens don't have the right to do citizens arrest. Is that correct, sort of?
In some places they do. I think in most places citizens arrest has been sort of repealed. Yeah.
Mm.
This one's going to be hard, I know.
Well, I guess on the principle of non-discrimination, which seemed to me to probably be the most important of the three, you had the idea, well, maybe traffic stops for speeding would be okay if they actually stopped everyone who was speeding, or everyone who was speeding by more than 10 miles an hour, or maybe, certain kind of crimes it would be okay to prosecute if they prosecute every single person who committed the crimes, or including policemen. But it seems to me that is a little bit kind of fantastical in terms of resource constraints. How is anyone ever going to arrest every car that's speeding if 98% of the cars are speeding? And how are prosecutors ever going to prosecute every crime when most of us probably commit a crime every day because so many things are criminalized? And so I just sort of wonder, if that's the remedy, how are you going to get around those kind of real world resource constraints?
Yeah, so there's always going to be discrimination in the broad sense of the term, discretion on the part of prosecutors to prosecute or not. I think my initial response to that is, yeah, we all commit crimes every day because there are too many crimes. So maybe if we don't have so much criminalization, I think that's the place to look. The problem is we don't really have any incentive to do anything about it because the status quo is good for so many people, and the people that it's not good for are not particularly powerful in the political arena. Once we say, no, the status quo can no longer exist, you have to think of something else to do. I agree. Stopping everybody if they're going 1 mile an hour, that is fantastical. And I put it there just sort of as a, that's not going to happen. Even stopping everybody going 5 miles an hour, but maybe if we had, cameras that take pictures of license plates every time I go on a trip, I get not a ticket, a invoice, I guess, in the mail because I took a toll road and they took a picture of my, if they can do that, the police can do that too. And it, again, maybe the fact that people are going 60 in a 55 means that maybe the speed limit should be higher, right? But we're not going to get there if the status quo is so attractive to so many people.
I think the term that on search is a reasonable expectation of privacy, and I've thought that privacy was an inferred right in the Constitution, and that Roe v. Wade was one of the crucial cases that gave us a right to privacy. Since that's been overturned, and also in the context of a time where privacy is, we almost have no reasonable expectation of privacy in the society we live in now. But I'm just wondering, particularly, I guess, in terms of overturning Roe v. Wade, if a reasonable expectation of privacy has a different legal context.
So that's a really good question, and it's our fault as lawyers for using the term privacy so loosely, because the right to privacy can mean a lot of different things. On the one hand, it can mean the rights we have under the Fourth Amendment, which you'll notice doesn't say anything about privacy. The word is not in there. It could also extend to things like abortion or using contraception or same-sex marriage or what have you. That's a very different kind of right. It's not really about privacy, right? A same-sex wedding doesn't take place in private, typically. That's more about a right to autonomy, right? Bodily autonomy, marital autonomy, autonomy in child rearing. So we're using the term privacy a little bit too loosely there. The more conservative elements on the Supreme Court have been against both of those things, right? Because they're not in the Constitution. So at least they're consistent, right? Justice Scalia, Justice Thomas, Justice Gorsuch, they don't like the reasonable expectation of privacy test because they say it has no foundation in the Constitution. It should, what the law was in 1791 was about property rights. Someone trespasses on your land, right? So that's a short answer, I guess.
I have a follow-up question. So historically, there was considerable debate on whether to have a Bill of Rights, and including the argument that there should not be one because once you enumerate rights, you risk eliminating rights that are inalienable and presumed. Mm-hmm. So it seems you could argue that if you're really dealing with originalism, the original thought was a broad spectrum of rights that are just recognized and assumed. So once we started to enumerate them, things like now you'll hear people say that we have a right to health care, and people will say, well, that's not in the Bill of Rights, we're not in the Constitution, but that wasn't the original concept. The broader thinkers constitutionally said we should not enumerate them. So I don't know, just what reflections you might have on that, and sort of the limits of getting to, I don't know, the limits of saying it's originalism.
Yeah, yeah. So a couple of answers to that. First, the people who thought that we should enumerate them won, right? The anti-federalists won that battle. So we do have a Bill of Rights, and they are enumerated. I think a more complete answer is that, again, let's remember that the Bill of Rights applied only to the federal government. So when they said we have other rights, what at least the anti-federalists were talking about, for the most part, was rights given to them by state law. So and if you read state constitutions, they dwarf the federal constitution in size because they have right to health care, right to schooling, right to housing, perhaps, right to medical care, all these kinds of things. So the way they handled that, I think, is by including the Ninth Amendment. And there's a great deal of disagreement over what exactly the Ninth Amendment means. The Ninth Amendment says, basically, just because we've enumerated these rights doesn't mean you don't have others, right? My sense of the Ninth Amendment is that again, it's a federalism provision. It says, just because you have these rights doesn't mean you can't rely on other rights under state law protecting you from the federal government, right? The thinking at the time was that states, at least by the Anti-Federalists, the Anti-Federalists were the ones who were originally opposed to the Constitution, right? The Federalists were the ones who were in favor of the Constitution. So the Anti-Federalists, they imagined the people and the states as sort of a unified front against the federal government, right? The 14th Amendment is very different. It imagines the individual and the federal government as being a unified front against the tyranny of the states. But back in 1791, they wanted, protection, and they assumed that the greatest protection would be the protection of state law, acting as a buffer between the individual and the federal government.
Those of us joining us online, you have a question and answer section. If you have a question, please feel free to submit it online.
So the 14th Amendment is really a federalist step in that direction, right? A federalist because...
No, the Bill of Rights is sort of federalism-based or states' rights-based.
But I mean, the 14th Amendment is sort of a modern step that way too, right? To federalism, because the federal government has more power, has the power over the states more so.
Yeah, I mean, I think we're using federalism in two different ways. I would say the 14th Amendment is designed to empower the federal government to protect people from their own states.
Okay.
Yeah.
Well, thank you. That was lovely. We had a great conversation and learned a lot about the Fourth Amendment and the 14th Amendment today. So here's a little thank you from us.
Oh, thank you. Thank you so much.
And we are on hiatus from our 6 at 6 series until January. Our next one is January 29th, and it's at the Cincinnati Art Museum, and it's Communities Lost and Found. We hope we'll see you then. Thank you.